Sean, welcome to the Bucks County Court Town Hall. This is Sean Gresh, and with me is Chris Brill, the co-chairs of the Bench and Bar Relations Committee of the Bucks County Bar Association.
You're muted, Sean.
Do it remotely. Greg, thanks. See you.
We'll start it until the.
Can you hear me now?
Called that one, right?
Hello.
You're lucky.
All right.
Technical difficulties.
Joining us today are the administrative judges of the Bucks County Court of Common Pleas. Leading us in this meeting will be Judge Robert Baldy, and going on your screen from left to right, Judge Theodore Fritsch, Judge Ray McHugh, Judge Jeff Finley, Judge Jim McMaster, and Court Administrator Steve Heckman. Also here with us is Bucks County Bar Association President Julie Goldstein. Let's just jump right into it. President Judge Bateman couldn't be here with us today, so Judge Baldy is going to help lead us off. Judge, there's some pending news and upcoming events that we wanted to talk about. First and foremost, I think, was the opening of the 5th floor and the scheduling of that. Would you rather talk about that, or would you like me to talk to Mr. Heckman about it?
I think Mr. Heckman would be the one to tell us about that.
Very well. Steve, what can you tell us about the 5th floor build out?
Sean, I can let you know that right now, construction is substantially complete on the 4 additional courtrooms we're putting on the 5th floor, along with the adjacent conference room / arbitration room. There are still a few odds and ends that have to be done, but they're working on that. The last of the biggest issues we were waiting for were the furnishings, that is the juror chairs and also chairs in the courtroom and some conference room tables. We expect, as of today, that they will be here by the middle of May. Now, at that point too, we also expect that we will get a use and occupancy permit to allow us to use those courtrooms by mid to late May, hopefully by May 16th. That's the good news. The bad news is that due to supply chain issues that everyone is well aware of all over the world, especially with the war in Ukraine, delivery of certain technical components necessary for the effective use of the courtrooms has been involved in repeated delays. As a result, for example, the microphone audio will not be operational until June. The courtroom audio video presentation technology for counsel to present evidence through technology will not be available for use until September. Finally, the courtroom sidebar microphones will not be functional until November. We still hope to be able to proceed with arbitrations and other hearings of that nature once we get the use and occupancy permit. But we have, as in any project like this, we do run into delays that affect the installation of the technology. And that's the biggest thing right now, the audio visual video technology. And until that's totally complete, the courtrooms will not be effectively useful until that time.
How many arbitration rooms do we have upstairs, Steve, or will we have upstairs?
I think we'll have 4.
Do you anticipate that all 4 of those will become available at the same time?
I'm hopeful, yes.
All right. And that would be once we have a UNO permit, maybe late May?
Correct.
Okay. I've posted in the chat for anybody who has any questions that they'd like to pose to the panel. Send it to me in the chat and we'll try and fit it in when we can.
I'm going to ask Steve a question, if I may. There 3 rooms look to me to be, for the arbitration rooms, to be complete. One is more substantial and looks more judicial, I'll call it.
Right.
It's pretty, and it's nice to see that set up. The other ones are going to need tables and chairs. But I would assume that those rooms would be usable as soon as we get an occupancy permit. Would you think that'd be correct?
That would be my understanding, Judge, yes.
All right, and I think it's going to be great for the bar when they see them. I think you're going to appreciate those rooms. They're on the floor. You'll be able to have people sitting out in the hallway in a, very much like if they were doing a trial. I think you're gonna much prefer the venue than what you've had to deal with up until then. So that's a great thing for the civil litigation. And let's go back again. Tell us about the use and occupancy permit, because that obviously is critical. We don't really know when we're going to get it, but the projection is when again. I think this is the date you should be thinking about.
The projection is May 16th. But I would use the word projection.
Right, right. So sometime after that, we can start using that floor. All right, thank you.
Chris.
Yeah. Thanks, Sean. And like Sean, I encourage everyone who has a question to let us know what that is, and we'll try to fit that in. And just getting back to Judge Baldy for a moment, Judge Baldy, would you just address briefly for us a topic that many of us were not familiar with, and that is that this year is apparently the 300th anniversary of the Bucks County Courts. Is that the case, and what plans, if any, are being made to celebrate that?
Right. Well, this is something that we, the bench, learned about earlier this year when we were at a conference. The Pennsylvania Supreme Court is the oldest court in the country. And to put this in a perspective, the Judiciary Act of 1722 was presented to Parliament, and it created the Pennsylvania Supreme Court. And that's what the big announcement was for us. But the smaller print also told us that same act created the Court of Common Pleas of Philadelphia, Bucks, and Chester County. So the Supreme Court this year is celebrating their 300th year anniversary. And if it's their 300th year anniversary, it's Bucks County's Court of Common Pleas 300 year anniversary, which I think is pretty exciting. When you consider Bucks County was founded in November of 1682. Bucks County is one of the 3 oldest counties in the state. They were the first 3 counties that were created in the state. Bucks County was one of them. So the Bucks County Court of Common Pleas is 300 years old. Congratulations, Bucks County Bar Association members. I think that's pretty cool. And we're going to try and do some sort of celebration. We had hoped to combine a celebration of the 300th year anniversary with an opening of our 5th floor, so that you'd all come in, you'd see the 5th floor, you'd see the new courtrooms, and we'd celebrate the 300th year anniversary. Because of the delay of the occupancy permit, we're not sure how that's going to work. I do hope that the Bar Association, and I think they're interested in doing something, and we, the court, would like to do something to recognize that 300th year anniversary. So hopefully there'll be news in the near future about both of those events. There's also a third event that Judge Bateman wanted me to tell you. The Superior Court will be sitting in Bucks County in Bonk sometime this year. Some of you may remember they did that a number of years ago. They're going to do that again this year. We don't have the date yet, but we will let you know. And maybe some of you will have arguments before the Superior Court, and you'll be doing them in the Doylestown Courthouse. But if you don't have an argument, you'll still be able to attend a session in the Superior Court if you choose to do so in Bucks County some point later in the year.
Thank you.
That was actually planned for March of 2020.
Correct.
Oh, I don't know if you heard Judge McMaster, but the original plan for the Superior Court was planned for March of 2020. So we're getting to it.
Judge Finley, I understand that you are aware of Judge Bateman's thoughts on when, if ever, meth will be reintroduced or required again in Bucks County. Can you share those thoughts with us?
I won't quote him directly,
Good idea.
but as a general rule, it is his anticipation that it will not occur during the remaining 20 months of his term as president judge. In reality, it's a decision that he will make in consultation with the Board of Judges based upon information from the Department of Health and the CDC, and frankly, how the numbers are going. I think a number of us, and Judge Bateman in particular, studies those numbers as they're presented as to rates of infection, rates of hospitalization. But I don't think he anticipates that occurring again.
I
in the
know
next-
we all,
in the next 20
we all
months.
hope that the data never suggests that there should be an issue on that at all. And you did mention, however, in your remarks that the next 20 months, it will be Judge Bateman who would preside over that decision. What happens after that 20-month period? Can you tell us, to those who may not be familiar with how president judges become president judges, can you explain briefly that process?
There are specific rules under the administration of the courts, how president judges get elected. If you're in a county of less than 7 judges, basically it's the most senior judge. And in many counties, that's judge for life, is judge and president judge. In counties 7 above where we fall, it is an election by the Board of Judges. It takes place on the first Monday after the new year. It's an office for 5 years. It's done by a plurality of the votes of the Board of Judges. It's for a 5-year term that cannot be, the president judge can't succeed themselves anymore. Rumor has it that was a rule initiated as a result of some matters in Bucks County many years ago. But as a general rule, what happens here is we get together around the lunch hour. We'll have a senior judge or somebody who really doesn't have a stake in the vote. And we take a vote. Generally, it's a blind vote where people submit the names and the votes are counted up. And a minute later, that individual is now the president judge. That's the way we do it. Not every county does it that way. Montgomery County and a couple other counties sort of elect a president judge in waiting. Montgomery County tends to do that about 6 months ahead of time, 6 months ahead of the term beginning. I know one other county that I'm aware of elects their president judge elect a year ahead, so that person can kind of sit as second chair. But tradition is in Bucks County, the vote takes place and that individual becomes the president judge right then, with or without any real prior knowledge of what the office entails.
And Judge Finley, as a former president judge yourself, you're in the perfect position to explain the answer to that question as to what does it entail to be a president judge versus just a regular old judge
You know, it's
or regular young judge.
it's not well defined. The only real well, actually, there's 2 that I'm aware of. That is the assignments of matters. And theoretically, a president judge could assign every case to the various judges. We tend to assign areas of practice and then cases get distributed elsewhere. And the other thing the president judge by statute is in charge of is the security of the Justice Center. So in reality, the president, not everybody agrees with my reading of this. The president judge oversees all policy pertaining to security for the Justice Center. So assignment of matters and security, but in reality, designating who are going to be the administrative judges, making determinations such as the fun ones, whether or not at 4 or 5 o'clock in the morning in discussion with the county commissioner, you're going to close the courts for the day. Handling issues arising out of the district courts. There's a lot of stuff that comes about out of it that really falls upon that office. It's not specifically spelled out that anywhere statutorily, but in reality oversees the operations of the court system in Bucks County.
But during your term as president judge, I suspect there were periods of time where the administrative aspects really took a lot of your time and attention, and not always consistent from day to day or week to week, but sometimes there would really be front and center.
It does. And let me say that this, nothing compared to what Judge Bateman's had to deal with between COVID and some other issues. I never thought I would say this, but I think I had it easy compared to what Skip has had to deal with over the last 3.5 years.
I don't remember any of us hearing you say you had it easy at the time.
No, I was ready to jump off the balcony a lot.
All right, so although you were going to be the next person to talk about updates on juvenile court, why don't we reshuffle the deck here a little bit and go to Judge McHugh who can tell us some of the updates from criminal court.
Okay, so in criminal court, I would think that everybody is getting used to the new restrictive probation. It replaces house arrest. It's not a Bucks County function, it's a statewide function. So when people complain to us about some of the rules that are in or concern restrictive probation, they're state rules and we can't change them. So we've rolled it out. It's working overall well. We've had some delays with defendants getting CRN evaluations or drug and alcohol evaluations. And we've had a problem with them getting those evaluations and then the agencies that are providing them not getting them to the probation department in time. So we've had a lot of delay problems. We've been working on that. I think we've made progress. We'll see. But we've done a couple of things that we've changed. That we changed the probation warrants so that if you get a probation warrant out, whether it acts as a detainer because you're arrested on new charges or you absconded or you haven't complied with the supervision, we used to just handle those matters as all bench warrants did. You would come in and have a purge or a bench warrant hearing that day. We now do them separately. If you're arrested, you're taken directly to the county jail where you will meet with probation officers. They will review your case, and within 48 hours, they'll have a recommendation to the judge whose probation or parole you're on as to whether you should be detained or you should be released or you should be released with conditions, or whether the court wants to have a hearing, a regular old-fashioned bench warrant hearing to determine how to proceed in that. So those things, those additions to the probation department work well. We have a backlog, obviously, from a number of cases being continued during the pandemic, not being able to have jury trials. And of course, when you don't have or don't offer jury trials, everybody wants a jury trial because that's how you stay out of jail. You know, if you're out on bail, you say, we want a trial by jury. And then as we schedule those, many of them resolve as soon as a jury comes into the courtroom, which is kind of normal in criminal court, but we've seen a lot of that. And as a result, people should see that we'll be at the end of this week, sending out a new continuance policy. We've watched civil courts. Judge Baldy has kind of a no tolerance. We're going to get this case in no matter what attitude, and it's worked well. And we're going to move some of that into criminal court. And, you know, part of it has been a problem because we've had issues with getting prisoners in from out of state institutions or from another county institution. We've had an issue with our jail putting somebody from a different facility into our jail, even if they're on trial in Bucks County. So we have to work out some of those, and some of the prison policies, especially since pandemic, have changed dramatically. And we're working with those, work with not just our county prison, although we have issues there, but with the state prisons, trying to get people in, and of course, trying to get them in so that they can meet with their attorneys to get ready for trial. All that timeliness is difficult, but we're working through it. And of course, as we go, we get better at it. So we're starting to see some results, and we're hoping that by the summer, we should be caught up and back onto a regular schedule.
Sean, you do criminal work. Do you have any questions on that?
I don't do criminal work anymore, but what I did have a couple of questions, but actually I think the judge covered them pretty well. The main question I had was about how the transport between our county prison and the state prison system has that come back into the fold, Judge, or is it still kind of haywire?
Well, so when you deal with the state, you have some bureaucracy right away. And you have some issues with them that can be frustrating. For instance, you're allowed to use new technology to assist for hearings, but you can't, for them, say, your attorney wants to talk to you for 5 minutes before we do this hearing. Please do that. No, they'll terminate the video then if you're not doing a hearing in the court. So, you have those types of problems. Every jail now has new rules regarding insurance and health protection. All of the health providers to the various counties and states, some are government, but some are private providers. So just navigating through those new rules are something that happens with prisons. It's difficult to get a prisoner from a state correctional institution down for a trial on time. So
I noticed in a couple cases that I've seen recently that the space of time between the conclusion of a preliminary hearing or the waiver of a preliminary hearing and the formal arraignment here in Doylestown, that space is down to about 5 weeks now. Has there been any thought or any discussion of possibly lengthening that to give the court more time to resolve the cases that are already on its plate and slow down the amount of new cases that are coming into the courts?
We've done that to a point. I will tell you, one of the things that we're looking at doing is differentiating between different types of cases. I mean, right now, every case is handled the same as every other case. So you could have an aggravated assault or an attempted murder or a murder, and it's handled the same way as the possession of a small amount of marijuana for personal use. In other words, you go to the preliminary hearing, you have a preliminary hearing. Then you get an arraignment date. Everybody gets the same arraignment date. Then you get a first listing date. And all of those are the same. And for some of the cases, it seems the quicker, easier cases, maybe ones that don't have a right to a jury trial, they should be on a much faster track than the majority of cases. And then the more serious cases should probably be on even a longer track, just to allow different types of cases, different time schedules. And that's what we're working towards. And we hope to have that in by the end of the year.
Thank you, Judge.
Sure.
Judge McMaster, do you have any updates for us about domestic court? What would you like to share with us?
Quite frankly, we've been, as far as court proceedings, doing court proceedings on a regular basis since June of 2020. So we don't have a backlog in that regard. We have had, for the months of March and April, back in February, I authorized the master's office and the domestic relations office to go back to having telephone or video conferencing for master's hearings and custody conferences and domestic relations conferences. We're about to go back to having them live, assuming the numbers stay where they are. Although I've had some attorneys, especially those who don't have their offices in Doylestown, who are happy to have some of those things being done by telephone because it saves them a lot of time and their clients a lot of money. So that's one of the issues we're debating as to whether we continue to have them despite the numbers going down as far as the pandemic is concerned.
Coming out of the pandemic, has it had any scheduling effects or practical effects on custody or support with people gaining and losing employment for support, or any specific or unique issues for custody court?
Not really. I mean, the issues have been relatively the same as they were before. The way we handle them has been slightly different. We do more things by telephone and stuff like that, but generally the issues are coming up the same.
Okay.
I mean, I was pleasantly surprised that we didn't get a massive number of people who lost their jobs and therefore support orders were needed to be adjusted. We didn't get that. We have some, but we didn't get as many as I was afraid we were going to have.
I was wondering, Judge McMaster, whether you've seen an uptake in the PFA petition as a result of the pandemic. Any statistics followed on that?
The trend has been, the numbers have been going up, and I don't know whether it's related to the pandemic.
All right.
I mean, the number of cases that we have on an average PFA list, which maybe was 3 or 4 years ago, was 20, now is getting to be 30 and up to 40.
I mean, you hear stories that people, when they were unable to come out, and you had basically had to hunker down in their house. If you were hunkering down in your house with someone who you didn't get along with, it would ordinarily result in more PFAs than otherwise. I don't know if since the masks were lifted, whether you've seen a decrease or any correlation at all.
Actually, how the sports teams do seems to have more of a impact than anything else.
Okay.
When the Eagles do poorly, the next week we have a higher number of protection from abuse cases come into the door.
That's horrible.
That's a shame.
Well, I think alcohol has a lot to do with it.
Well, Judge Fritsch, we're here to discuss any updates and new and improved things. I know Orphans Court is a hotbed of updates and things change there every day, or at least every century or so, right?
Right, yes.
What's the latest in Orphans Court?
Anything post 19th century is new in Orphans Court, but I'll start talking about scheduling. And for those of you who practice in Orphans Court, as you know, since the pandemic started, we've been scheduling cases at specific times during the day, rather than the prior practice of scheduling 6 or 8 cases at 10 o'clock and just seeing how fast we can run through them. And we are going to continue with the specific time scheduling for Orphans Court cases. I've spoken to Orphans Court attorneys who seem to very much prefer that, of course, knowing exactly when they'll be starting. As far as we judges are concerned, it can make the day a little bit choppy. And also perhaps we're scheduling cases later in the day than we might like at 2:30 or 3 or even sometimes 3:30. But we are going to stay with the system of listing cases at specific times. And again, Orphans Court practitioners seem to be very pleased with that as far as the ones that I have talked to about it. As far as who is sitting in Orphans Court, you're going to be seeing more of Judge Trauger in Orphans Court, filling in for me when I'm not sitting, and less of Judge Gilman. As all of you know, Judge Gibbons is retiring. We have fewer judges in criminal court, and Judge Gilman is needed there. So he's going to be, at least in the near future, sitting in criminal court most of the time, the great majority of the time. And so you'll be seeing less of him and more of Judge Trauger in Orphans Court. As far as our docket is concerned, we do not have a backlog, although our docket in Orphans Court is very full. Even in complex cases, we can give attorneys hearings within 60 or 90 days. So cases are moving in Orphans Court, although we have a very full docket. It does seem we've had more emergency cases recently with respect to emergency guardianship cases and area agency on aging protective services cases. Sometimes we get 3 or 4 a week as far as emergency cases that have to be listed when they can be fit in. But at any rate, cases are moving in Orphans Court. For those of you who do guardianship cases, we do have the fairly new guardianship tracking system with respect to online filing of guardianship reports. That seems to be going fairly well. Most people are filing online rather than by paper. If people are having technical difficulties filing online, there is a help desk at AOPC which can help people. And of course, we have Eric Martel as our guardianship review officer, and he's a great help to practitioners. not only with respect to GTS, but also with respect to filings. He has templates and can help attorneys out who don't practice very often in orphans court, but again, make a foray into orphans court every once in a while. So that really is basically what's going on in orphans court. There have been a lot of rule changes, but of course, again, that's too tedious to talk about. Sean, you practice in orphans court. Are there any questions you have?
One question that I know I have, and other practitioners have also brought up, what's the status of potential e-filing in orphans court, Judge?
Well, e-filing in orphans court, I think, is something that is going to happen eventually. We haven't approved it yet, but again, I think it is coming. We judges, as far as most of us being older, like paper files, and that's a little bit of the hitch. We have to have a system that's kind of hybrid first, and before we move into a paperless system. But I think that is in the works.
And with the primary reliance now on yourself and Judge Trauger in orphans court and Judge Gilman doing less orphans court, overall, will there be less capacity, less hours in orphans court? Do you envision any sort of, not necessarily a backlog, but a difficulty in obtaining enough time to try a difficult orphans court case?
No, our goal is to have a judge sitting in orphans court every day of the month and the year. We haven't quite been able to do that in the past, but no, we don't envision a situation where there will be fewer judges each day in orphans court. Most counties our size have about, on the average, a judge and a half sitting in orphans court every day. We have about one judge. So we have to, again, we have to work reasonably hard to keep up with our caseload.
Thank you, Judge. One thing that came in while we've been talking, and it was on the tail end of our discussion regarding PFAs, I noted, and I didn't realize this, our prothonotary Colleen Christian is joining us on the video conference. She posted here in the chat for everybody that PFA filings are up 27%, which is a pretty big number. So I wanted to share that up, and thank you, Ms. Christian, for joining us. While I'm at it, I guess I should also thank our DA, Matt Weintraub, who I also see here for joining us. Thanks for being here, Matt. With that in mind, and that gentle segue into criminal, pseudo criminal court with the DA, Judge Finley, can you give us any updates on juvenile court?
Pseudo criminal court.
Well, because it's not juvenile offenses are not crimes.
The biggest change in juvenile court that's occurred over the last few years has been the addition of Judge Bowman, who sits with me in juvenile court. And as you know, the three of you that practice juvenile court work, we sit 2 days a week, Tuesdays and Fridays, and Judge Bowman and I probably share it about 50-50, I would think, pretty close to that. Crime, juvenile crime was certainly down during the pandemic. As school was out, you didn't have as many opportunities for fights in the hallways or the possession sort of things. So we have not run into any backlog by any means. Obviously, things are picking up. We have, of late, in my opinion, had more serious crimes committed by persons that are getting near the age of 18, so that we have what people think of as certification or transfer back proceedings, a bunch of those in the works. The biggest issue, in my opinion, over the pandemic was as it pertains to quarantining. When a kid, and there's very few kids that we place outside of Bucks County, very few kids we put in placement, but those that we did over the last 2 years, when you would want to send them to an appropriate facility, usually they had to be held in quarantine for 14 days. Then they would go and be held in quarantine 14 days at that location before they could really begin to engage in treatment. That has largely resolved itself, not completely, but it has resolved itself. One of the things people ought to know about juvenile court is that the flip side of what I was just saying about placement is most kids that get in trouble are handled within this county without going away to some form of placement. Not only do we have the juvenile probation officers, but we have a bunch of agencies that we work in concert with. And they are the people that follow through and do routine drug testing, who make sure kids are doing community service, who make sure kids are going to their counselors and therapists, that are providing small groups, that are working with Big Brothers or Neighborhood First in mentoring programs. So we try to keep Bucks County kids in Bucks County. The goal is to have the kids with the lowest level offenses to have the least amount of contact within in the system, because the studies show that the further in the system you get sucked, the more significant your criminal history will develop. So we try hard to stay out of that, and we work closely with these agencies. And when we see Judge Bowman and myself and Chief Probation Officer Ted Rice, we see a need for something, or something comes up that we learn of that might be beneficial, some new program, we can prevail upon one of our agencies to develop a program to deal with that. And we've been really successful with it. So the things that were the problems, kids not being brought in, having to do everything by video conferencing, have largely been reduced. I'm not a fan of it. Juvenile court is one of those areas of the law where the Supreme Court has given a great deal of authority to handle matters by advanced communication technologies, I think is the terminology. I'm concerned that it's been used to some extent by some of our more irresponsible parents to play a minimal role in their child's life. And so rather than take the time to come into a courtroom and speak on behalf of their child, they would rather literally phone it in. And I'm not a fan of it, but I'm going to do as much as I can to discourage it. But it's there and it will continue. And when the need is there for video conference matters, especially kids out of state, those rare kids, that's what we do.
Do you find a practical benefit in having the juvenile live in the courtroom versus over video technology?
Absolutely. To me, and Judge Bowman's here, maybe she feels differently, but to see the kid's face, see the kid's posture, good and bad, I read a lot into that. I wasn't a fan of the video conferencing especially for the kid, for the juvenile themselves. I just thought that was it was a poor way to do it. It was what we had to do, but it wasn't beneficial.
Have you noticed a difference in volume versus pre-pandemic versus now as far as intakes that you're doing?
Pre-pandemic versus now.
Do you remember pre-pandemic?
Yeah, I'm getting old.
Not getting.
I would say juvenile crime is down a little bit. Serious juvenile crime, I think, is up. But I think overall, I haven't looked at the numbers, but I think they're down a little bit.
That's good to hear.
Judge Baldy, being a civil practitioner myself, I'm happy that we saved the best for last. That is the topic of civil law and any updates on civil practice you'd like to share with us.
2
Well,
minutes.
Civil was fortunate. We didn't have the problems that criminal did. So we were able to keep our cases flowing during the pandemic with 8-member juries. And that really helped us a lot. We have absolutely no backlog. Not only do we not have a backlog, but to give you a perspective, when you certify your case is ready for trial, we can give you a trial anywhere from 6 or 7 weeks to maybe 10 weeks. So we're back to the track where we were pre-pandemic. Now, that doesn't include the med mals. We're backed up on med mals, but we're actually doing okay, I think, bringing them in, giving them day certains. We're in that process now, weeding those out, and some of those are getting settled. The med mals, for the most part, only get settled when you give them a courtroom and a date, but we're getting those done. Every case on every trial list, when you get notice that you're on your trial list, you should be aware of several things. First of all, you're going to have a pre-trial phone conference. That's something we started doing during the pandemic, and it's been very effective at getting the lawyers to talk to each other. And you need to file your 212 pre-trial statement before the phone conference happens. You need to talk to the other lawyer before the phone conference happens. Because during that phone conference, you're going to be talking to either me or Judge Trauger. You're going to be telling us about the trial. And I'm not a micromanager, but for the first time in my life, I'm micromanaging something. And that is the specific cases, which ones get called first, which ones get called second. And you should know, if you're on the trial list, we have not, passed over almost any case in the last 6-8 months. We've reached them all. Now, when I say we've reached them all, there are cases that get settled. There are cases where all the lawyers agree to continue it for whatever reason. But if you have people who want to get their case into a courtroom, you will get reached and you will be brought in. So I find it amusing when I hear people talking to somebody from another county, and I'm hearing them say, well, this is the first time we've been listed, we probably won't be reached. No, you're going to be reached. So
Judge-
be aware of that, be prepared, and talk to your colleagues and understand that civil cases are just moving, and numbers are actually now being posted online monthly, almost monthly, for all the counties, giving county statistics on how fast the cases are going through and passing. And Bucks County's numbers are very, very good in terms of us getting cases handled in and out and accomplished. So you practitioners who are practicing in civil court, you're doing a great job. Keep up the good work.
Judge, how far out are you on date certain scheduling for something like multiple party litigation or med mal litigation?
Well, I've been bringing people in, and because some cases have gotten settled, I've been able to offer some people dates earlier than I thought I was going to be able to. And so far, we've gotten cases, given them a date within 6 months of when they've come in for a conference, and some have been later. Now, what's happened, an awful lot of the lawyers are now getting tied up like they did during COVID. Philadelphia and Montgomery, Philadelphia is open. I mean, Philadelphia is open for business. One of the administrative judge, head of civil in Philadelphia, told me that he tells the med mal lawyers, where do you hear this? You pick a date and we will schedule the trial on your date. You have any time between now and 8 months from now. And the lawyers can pick a date, and Philadelphia has enough judges and enough courtrooms that the lawyers can pick their own date. That's the only county that I know that can do that. Other counties I know aren't even scheduling trials. We're scheduling them. I have a problem because we don't have an accurate court calendar past December. So I'm going to go ahead, and I've been doing this, I'm going to start assigning cases for when I think there's going to be trial week next year. And I'm just going to start assigning them day certains. And I'll explain it to the lawyers when they come in, how we'll work with them. But so far, they've been accepting of that and saying, that works for us, that's fine. But that's how we're going to do it. But we don't, unless you have a court calendar, it's pretty hard for me to give you a date.
As a general practice, when is the court's calendar for next year typically ready?
What do you think, Judge Finley? Maybe
Mr. Heckman?
August?
Yeah.
August, sometime around August, maybe.
And Judge Baldy, talking about Med-Mal courtrooms and multi-party courtrooms, do I understand that on the fifth floor, one of the courtrooms is going to be appropriate for that?
I've been told that the biggest courtroom, not the biggest, there's a ceremonial courtroom that's almost the size of this courtroom. And then there's another courtroom, it's oddly shaped, I'll put it, it's very wide. But we are going to have 7 counsel tables in that courtroom. So if you have a Med-Mal case that's got multiple defendants, lots of them, the lawyers are going to be surprised to have their own table. It's going to be something new for some of these people. And that courtroom, I've been told, is going to be basically given to civil, but it's going to be shared. I know Orphans Court, Judge Fritsch has said he's got a couple of cases where he could use that courtroom. And I'm sure that there will be a case now and then from criminal where there'll be multiple defendants and they'll want to use that courtroom. But I think that courtroom is going to be primarily for civil. I've been told that, and we'll see if that happens.
One of the questions that a lot of people raise is, how does a party get a settlement conference in Bucks County?
It's really difficult. You either have to call and ask or send an email and ask. And it's really, really difficult.
Who do they call? Who do they
You
send
could
emails
call
to?
court administration, you could call my judicial assistant, or emailer would be the best way to do it. But if you send an email to court administration, I guess they usually go to Sherry, is that where they would go to? And when I do my phone conferences, my pretrial phone conferences, Judge Trauger does it, we say to the lawyers, do you think a settlement conference would help you? And a lot say no, or, whatever, but it's always been very simple. And there are a number of us who will sit and do settlement conference. Judge Core has been kind enough, because he's got a very extensive civil background. He stepped in and done some, even though he's not assigned to civil. Judge Bowman has had lawyers call her up because they know of her past experience of doing business law, doing all kinds of stuff, where they've said, could Judge Bowman do this settlement conference or whatever? She said, fine. So if lawyers would ask for it, they would be able to get one. That's
And
how
so
difficult
are
it is.
lawyers permitted to specifically request a particular judge?
It would not offend me the least. And if they wanted a particular judge, I would ask that judge. I will say this, if it comes to me, I suppose they could reach out to the individual judge, but the individual judges might actually prefer that you do it to court administration or send it to me. I haven't really asked I haven't asked my colleagues, how would you prefer this to be handled? It's not been a problem so far, but I know that the judges, are happy to get involved.
Judge, which judges are currently assigned to civil jury trials?
Myself, Judge Trauger, Judge Bowman sits sometimes. Judge McMaster will handle Med-Mal cases. Judge Mellon has started to help us out. And Judge Core's got a Med-Mal case assigned to him early next year. So what happens in civil, the other administrative judges say, why is this judge sitting in civil? And I say, they want to do civil work. They want to. And then the other administrative judges and the president judge yells at me sometimes and say, you shouldn't do that. But there are a number of people up here who actually like to do civil work and would like to do more than one thing. So I'm happy to have them. I would say to you, going forward, I think the primary civil judges are going to be me, Judge Trauger, and Judge Mellon. I think are the primary ones. And then but I think other judges from time to time, to the extent they can convince their administrative judge and the president judge to let them, I think they will also do more. And I'd like them to do more. They do a great work at it.
Judge, you and Court Administrator Heckman spoke earlier about the arbitration rooms we'll have upstairs,
right,
and the 5th floor. As a practical matter, how will the actual handling of arbitrations where will litigants check in? Will it still be down in the jury room?
I'm glad you asked that, because since I've been a judge, I've not even seen how arbitrations, where they go or where they work. I've never seen an arbitration in process. I don't even know what you do now. It's just something that happens outside of me. I don't know a thing about it. Maybe Mr. Heckman does. I know nothing about arbitrations, other than they're not in front of me.
Mr. Heckman, you can consider the buck passed.
No, they do still check in the jury lounge area when we do them on miscellaneous weeks. And then the assignments are made from there. And I presume that'll continue and they'll just be directed up to the arbitration rooms on the 5th floor.
So the only thing that'll change will be the location of the actual hearings. The check-in will still be down in the basement.
As of right now, correct.
Okay, thank you.
And you'll stop referring people to very nondescript rooms as is current custom is, but
Yeah, we'll try and make it more suitable for an arbitration hearing.
very good. We're wondering whether anything that was said so far before we close would prompt any of the judges to offer any other comments. So you're Sean.
No? All right, well, I think we've covered all of the questions that we've gotten from the group. One thing that I was asked to remind everybody of, considering the uptick that we've noted today in PFAs, if anyone out there is interested in volunteering to help with PFA court, as you know, Legal Aid and the Bar Association join forces to help volunteer to represent PFA litigants. If you're interested in volunteering to represent plaintiffs in PFAs, please reach out to Legal Aid to help and assist with that. If you're interested in assisting and volunteering as pro bono counsel for PFA defense, please reach out to the Bar Association. They could certainly use your help. If there is nothing else, I'd like to thank all of our participants today for their time and their energies toward making this a successful program. Thank you, everyone, and we'll be adjourned.
Thank you.
Thank you.
Thank you.
I was gonna say.